Good morning. It's probably by the time you see this, it'll be afternoon, but that's fine. We have a docket entry, number 112. The court has denied Chiles' motion to strike. Yes, I am happy. Yes, I'm glad I was wrong. I thought the court was going to strike it. Now, the court played very fast and loose. Very fast and loose. The court cited 3 cases that stood for the proposition that the court still had discretion and completely ignored the fact that the court didn't have discretion. The cases that the court cited were cases where the attorneys had asked for the leave to grant prior to, for an extension prior to, the attorneys had asked for extensions prior to filing their late filed responses or what have you. So in this case, we had a response filed before. And again, people don't really get the distinction. The distinction is courts have a lot of discretion in a lot of things, unless that discretion is taken away from them by statute or by the Constitution or by something else, by a higher court case, by a case that is stare decisis, that's binding. So the courts have discretion until they don't. And in this particular case, I agree with Chile that the federal rules of civil procedure strip the court of that discretion. It's pretty obvious. The case that he cited was very on point. The cases that the court cited to say that the court still had discretion were not on point. But that's fine. That's fine. This is a win for Kate. And Chile's alternative, if he wants to, is to appeal this. And that would, if Chile appeals this, Chile could get his name on an actual opinion that would have some merit, that would be binding, if the Court of Appeals accepts the appeal and actually issues an opinion. But that would be very interesting. And, that would be something that I think would be a meritorious appeal for Chile. Now, that said, I don't think that even if Chile wins on appeal, that anything different happens. I still don't think that the court is going to grant the contempt motion from Chile. The court has telegraphed, essentially, it's not going to grant the contempt motion. That's the court is saying, like, no, you lose, dude. Like, no, you lose. No, you lose. You're going to lose. I take this as an indication of the court's position about Chile and Chile's case and Chile's motion practice. I don't think the court is very much interested in Chile's motion practice at this point. So I would take that as a sign that Chile needs to maybe stop being such a dick and stop being so pushy and stop filing frivolous shit, and that he's going to lose his motion for contempt. But if he appeals it, then he at least would get some case law in his name on point, and he might be happy about that. But then again, if they kick it back down to the court and the court has to consider the contempt without this or whatever, then the court might just do like an OSC, order to show cause, ordering Kate to respond why she shouldn't be held in contempt or something like that. So, or finding independently, sua sponte, that the court's prior orders were vague and thus unenforceable or whatever. The court can deal with it in other ways. The court didn't have to do it this way, but the court chose to do it this way. And it tells us a lot about the court's mental state, about what the court is the direction the court wants to move in. I don't think the court is interested in any more motion practice by Chile DeCastro. I think the court's had its fill of it. Now, as far as Wish is concerned, Wish is still a piece of shit, and my opinion. And he did not do any legal research to get even any of these cases that were even close. That would suggest that the court had discretion, because what Chile cited cases that were not directly on, or that were not stare decisis, that were not binding, but at least they addressed the issue directly, and they were persuasive, and they based their opinions on Supreme Court cases, which would be binding. And so they were good cases. They were good citations. And Benjamin Wish, on the other hand, the licensed practicing attorney who's getting paid for his efforts, provided nothing. no case law, nothing to suggest that the court should rule in his favor. Forcing the court to do the research for him. And the court didn't have to. The court never has to. The court could be like, well, you didn't show anything. Like, no, piss off. The court is much more likely to do that for a pro se litigant than for an attorney. So Wish still sucks. Wish did a shit job. No bonus points to Wish. He should have asked for leave to file it first. He should have been on top of it first. It was still his mistake. It was still his responsibility. And just because he got lucky and the court did the work for him and the court wanted to come to that decision for him does not absolve him of any of his wrongdoing as far as I'm concerned. So, congratulations, Kate. This might cost you more money because Chile might appeal it. And wouldn't that be a hoot? Let's see Chile's appellate practice go off. That'd be more fun. Anyway, so there you go. Congratulations, Kate. My sympathies, Chile. You had a winner. But the court said F you, buddy. Anyway, thanks for watching. Have a great day.